morning, I need my accompaniments. We're going to talk about theories and themes of cases and a little bit about persuasion and some of the things that we do every day to be good lawyers. But I think if you keep these things in mind while you're here, it will help you get through this process that we're about to do. First of all, there are no wrong ways of doing anything here at the college. You're here to experiment, to learn new things, to be creative, to try it in ways that you've never tried it before. So we first want you to be creative, okay? And creative in how you think about cases, how you view the world. All of those things we want you to bring together here at the college. We want you to be courageous. That means being willing to change, to try to do something a way that's different, to think about it in a different way, to stretch yourself, all right? And the next problem is going to be, or the next thing we're interested in you doing, is being committed. And that means that you're going to be asked to commit yourself to your craft in a way that you have never committed yourself to this craft before. People are going to ask you to stretch, to think about things in new ways. This is going to be a wonderful experience if you take advantage of it. If you don't say, we can't do this in my jurisdiction, we're used to hearing that, okay? And you don't say, my judges won't let me do this. There's no judge in the world that has let me do anything. And every time I have thought about having a judge let me do something, the ultimate end of it, the whole purpose of this exercise is so that you can avoid this posture at your closing argument. We're going to take the begging out of this business, okay? And we've all begged, okay? I've begged. I've been a part of that process. And everything we talk about, you should know that every one of the instructors here has done it, has learned to do it another way. So don't be ashamed of anything that you're doing. Don't be afraid. That's what I want you to start this lecture with. Next slide. We're going to talk about persuasion and how you persuade people. I thought the greatest line in the movie involving Idi Amin was when the doctor came in and said, well, you shouldn't have killed all those Indian people. I told you that there was a reason for that. And Amin looked up and said, well, you didn't persuade me. Well, that's what jurors are looking at us. They're looking at us to be the instrument that persuades them of the innocence of our client. And there are ways that we have to do that. And I have to mention. This is what you should think about when you think about a theory or a theme of a case. From the facts of the case, you should develop a short phrase that conveys the essence of the case and that can be repeated during the dramatic moments of a trial. Next slide, please. Trial. I believe firmly that a trial consists of a series of dramatic moments. For instance, you are all familiar with the silence that you feel and what you feel inside moments before your opening statement. Every eye in the courtroom is focused on you, and they're waiting for you to say or do something. And I've seen lawyers all over the country get up, and at that very moment, what do? They introduce themselves for the 15th time to the court. Well, it's a very natural thing. Public speaking is a very difficult thing to do. Most people don't like to do it. And what happens at that moment to lawyers is that they're fearful. Inside. You know what those emotions are. Every one of you have felt it. I felt it. How do I start this? How do I get this going? What do I say? What happens is all of that angst that you feel at that moment gets converted into saying nothing and not capturing that dramatic moment. Think about the stage that you're on at that particular point. Your opponent for 20 or 30 or 40 or several hours has gotten up and excoriated your client. Called your client a murderer, a killer, a rapist, a terrorist, told how they were going to prove their story. Because the prosecution always has a story. They always frame an issue in the most negative way that they possibly can. And in that moment of that silence, what is the jury expecting from you? Ma'am, what are they expecting from you?
To tell them the other side of the story?
They're expecting something that is going to get them emotionally involved in your defense. In the reasons why what they just heard is not the story of the case. Okay? They're expecting something from you. They're anticipating something from you. And if you get up and say, ladies and gentlemen, my client is presumed innocent, and the burden of proof is on the government. And you'll find out what all of that means after the trial is over and the judge reads you the jury instructions. That's us. We do that. What other story happens in the world, where somebody else has to interpret what the story is and define it for the audience? Can you imagine going to a play on Broadway where you sit for several hours and then somebody walks out, approaches the podium and says, now let me tell you what this story was about. We routinely do that in courtrooms in an anticipation that that somehow is going to convince people of something. It only convinces people of the guilt of our client. That's all it does. Next slide, please. Another dramatic moment in the trial, obviously, is when you cross-examine the government's main witness. This has been another opportunity for lawyers to introduce themselves. Oh, Mr. Barr, I'm the defense lawyer. By this time, everybody in the courtroom knows who the hell they are. You are, unless you put them so deeply to sleep that they just woke up at this point. You gotta understand that we live in a society that is real upfront. Nothing takes time in our society. And we'll talk about that a little bit more. Next slide, please. Closing argument. This is the Perry Mason effect. We've done absolutely nothing during the course of the trial to convince anybody of anything. And now, through our words and articulation and our ability to quote scripture, we are now going to tell the jury why they should let our client go. And as the scripture falls on deaf ears, because if you've done nothing before this point to persuade people, you're not going to persuade them in closing argument. I don't care how great an orator you are, Barack Obama, but you're not going to convince anybody that late in the game. So let's move on. One of the things that having a theory or a theme allows you to do in a case is to create your own set of dramatic moments. Beyond those that are part of the process, the three that we talked about are three that are part of the process. They are, in every case, built into the process. And you must learn to take advantage of them. You know, if you have, for instance, again, talking about cross-examination, if you have the biggest liar on the witness stand, why would you want to know it? Why would you want to be his friend? Why would you want to introduce yourself? What you need to convey is that he's a liar. And you need to do that very quickly. Again, there is nothing in this society that doesn't happen fast. And you got to take advantage of it. So what I want you to do is use that short phrase to create a series of dramatic moments that can be repeated throughout the case as if it were a refrain in a song. So that the jury begins to understand this case in that framing. And we're going to talk a little bit about framing before this is over. But the idea is to find a phrase that sets out what your theory of this case is. Okay? The next slide. Important point. People remember the first and last thing you say. This again goes to the notion of you got to say something important in the first 2 minutes that you stand before that jury. And every time you get up, you got to say something important. You have got to be seen in the courtroom as the person who knows the most about this case. The disadvantage that we often have in thinking in the old ways that we think is that we give up that frame, that initiative to the other side. Those of you who play chess understand that white moves first. I've always wondered about that. And that's called the initiative. And black's duty in a chess game, black spends its whole time trying to overcome the initiative that white has created. What we want you to do, because they speak first, is to learn to overcome the initiative that they have. And that's what a theory and a theme in a case allows you to do. Okay? What we're going to get you to start doing here is rather than talking about defenses as we've talked about them and learned about them in law school, we're going to talk about storytelling. We want your defense to be a story. The government always has a story. They always have a list of dramatic events that have occurred, and they tell it as a story. And arrayed against that is our bullshit. And what do I mean by that? Ladies and gentlemen, my client is presumed innocent. Arrayed against that story is a whole host of legal theories. This case is about the credibility of witnesses. Let's talk about things like that for a moment. Credibility of witnesses. How many of you are married? Okay. You come home late one night, or your husband comes home late one night, and you're waiting for him, and you've been waiting for him for a couple hours, and he tells you a bullshit story. Do you say to him, you don't have any credibility? Or do you say you're full of shit? You say, you're not telling me the truth. The only people that talk about things like credibility are lawyers. That's not how people communicate with one another on a day-to-day basis. And who are you trying to communicate with? Certainly you can talk to me about credibility. I understand what the hell you're talking about. But do you think you can talk to lay people about things like credibility? And once again, rely on the judge to tell the jury this is what I mean by credibility. I want you to think about that. Because we use such stilted language in courtrooms, we expect people to understand what the hell we're talking about. And we're going to talk more about that. But a story is a way to communicate in a persuasive manner. against their story, you need a story. And you must remember certain key things about a story. A story has a beginning, it has a middle, and it has an end. And all you have to do, if you need to think about storytelling, is to go back and read your children's fairy tale book. I'm not talking about doing anything hard here. I'm talking about learning to think about facts in a different way. And the important thing is that you be able to match the government when they have a story to tell. You have a different story to tell. And what the jury then has to decide is which story is true. And they decide that on many different bases. Who they trust, who they believe, who appears to know more about the case. All of those things become elements of what a jury will believe is true. And if you're not telling the story, you take elements out of the game that you need to have and weapons that you need to have to force the government into a position where when those people get up and go back to the guilty room, there's people in there fighting for you because they don't believe your story. Next, please. I want to talk to you about how we produce information in today's world. We have the internet. We have situations where people don't even talk to one another anymore. People don't read anymore. People don't think anymore. This is the 21st century. And it's important for you to understand how we gather information. People, rather than read whole newspapers, read blogs. People look to the easiest way to get information that they can. In a time-consuming society, time is important. So it's not like people sit down and read the New York Times every day. Now, I want you to think about a courtroom and how we produce information in a courtroom. A courtroom is a creature of the 17th century. It has not changed very much from that time. When we want to put a piece of evidence in, we pick it up, I show you what's been marked as exhibit number 2B. Nobody knows what the fuck it is. Can you identify? Well, in the real world, people don't communicate like that. People don't communicate like that. We're in a 21st century world, and we're using 17th century techniques to try to communicate with a 21st century jury. You got to understand what that's all about. Because a lot of what happens in a courtroom makes communication and persuasion difficult. Because of all the technical rules we use to do things that are very simple in the real world. You know, nobody says to a friend, I show you what's been marked as Exhibit A, can you identify? All right. And that's clever and nice, and it's glad that we know our craft, but we got to understand what's happening. Those folks sitting in that jury box, if they don't know it, they don't see it, they don't understand what the hell you're doing, they're going to sleep. They're going to sleep. So when you walk into a courtroom, when you start this process, you got to understand that you got to overcome the nature of what we do every day and how it relates to the society in which we live. Next slide, please. When a jury walks into a courtroom, these are things that jurors are thinking about. All right? First of all, most of them don't want to be there. Am I kidding? Isn't that your experience? So they're thinking about their lives, right? And what we're being asked to do is take them out of their lives and put them into the life of someone else. So let's talk about it. Are there some other things they might be thinking about? How about somebody out there? Sex. We knew that's where you were. They get a couple hours of you talking about sex. Just a few, a little bit. Okay. Somebody out there. What else? Excuse me?
Oh, it's up there.
Courage, I can't hear you.
The cost of childcare.
The cost of childcare. What else might they be thinking about? Relationships. What kind of relationships?
Sex.
You can tell who's on the family.
Fight with a spouse.
Fight with a spouse. What else?
I wonder what that guy did.
Hmm?
I wonder what that guy did, meaning our client.
Oh, you think they're really thinking about our client?
Yeah.
Where do you practice?
Let's go back in
Where do you practice?
Miami.
I want to come to Miami where they think about our client. What else might they be thinking about in their own life? Yes, ma'am. How long is it going to take? Okay, what else? How do I get out of it? Right.
Amen.
What else?
Her job.
Their job. What else?
Bad weather.
Hmm?
Mortgage payments.
Mortgage payments. What else?
Which lawyer's gonna tell the biggest lie?
Oh, they think about lawyers in your jurisdiction. I'm talking about what are they thinking about when they walk in, they know nothing about the case.
They're probably thinking, oh God, I hope I don't get stuck with these other 11 people I don't know.
Right, one of those other things. So you got to understand that these people have their own lives, their own thoughts, their own places to be. They're probably thinking about what's on my email, because they took my computer away from me. Or why can't I read my newspaper? Or if I got to be here, why can't I do some of the things that I want to do? And how long am I going to sit here and wait? And what are these idiot lawyers going to ask me? They're thinking about their lives, their children, their spouses, their families, their businesses, their mortgages. Is this going to ruin my week? Am I going to keep my business open? Am I going to be able to get paid? Is my employer going to do all of those things? That shit don't have anything to do with your case. Now you got to take them out of that world and bring them into a world where you can convince them of something very important in someone else's life. Now, this is the most ubiquitous device in America. All right? And it's an illustration. What happens when you get bored? You change the channel. Right? Now, what happens? What's the best channel to watch if you're an insomniac and you want to sleep? Court TV. 20 minutes of court TV will put anybody to sleep. All right? And it will put people who are lawyers to sleep. So if these are people who are committed to the system and thinking about the system and what have you, and enjoying being it, and they can't take it because it's too boring, what do you think those people sitting in the jury box are thinking about during that period of time? Each one of those individuals, I want you all to remember this. If you remember nothing else I said, each of those people who are then in the jury box and on that panel, each one of them has one of those in their hand. And the moment you begin to bore them, the moment you begin to say things that don't capture them, what they do is they pull it out and they go bang. And they're back into those other things that their life is about. So you cannot allow them to use that most ubiquitous device. Because if you do, then you got to work twice as hard to get them back. So when you walk into a courtroom from now on, remember, out in front of each juror is a clip. And they will turn you off within 5 seconds. You can offer them nothing else other than your name and the fact that you're an attorney. Next slide, please. I want to talk about things like opening statement for just a moment. Can I tell a story about opening statements? Because it's true of lawyers. Because what we do is hard. Because it is difficult to stand up and talk in front of people. We are always worried about how we are some lawyer got up, he was doing an opening statement, and he was doing it in front of a whole bunch of other lawyers and the jury, they didn't come, they thought he was the great lawyer. And he said, ladies and gentlemen, I'm going to give an opening statement. And what you must remember is, opening statement is like a road map. Every lawyer in the room wrote it down. Opening statement, I can say that. I can do that. That helps me get where I want to go. All right? And so then that became sort of a legendary thing. Judges even say, you walked into courtrooms when they instructed, opening statement is like a road map. Opening statement ain't anything like a fucking road map. All right? There's no routes, no signs, no nothing on there, right? The next thing we say is, we say, hello, my name is Bill Moffitt. Thank you for your patience. What the fuck have they been patient about? All right? All right? The next one, the one I love, the begging begins early. Okay? Please keep an open mind. All right? Total beg. This shit you just heard from the prosecutor is so bad that you need to keep a fucking open mind. All right? It's awful. All right? But I want you to remember that at some point in this thing, the judge is going to tell you what I'm talking about. All right? The next one is reserve judgment. Please don't judge him based on what just happened. Please. And then the coup de grace. Because we got to say something. Nothing I say is evidence. Don't listen to a fucking thing I say. It doesn't matter. It simply does not matter. Okay? Next slide. Then what we do is we insert our legal term. This case is about the defendant, my client, and alias, the credibility of the witness. Right? Burden of proof. Self-defense. The presumption of innocence. Some other dude did it. So did. Now, let me talk to you about this for a second. You now have an opening statement. You do those 4 things, you go back, and I've done them. I've done every one of those things. That's why I can write about it. And the reason I did them, because what I wanted to do is I didn't want anybody to see me or know I had said a word. And it was a way to deal with what was going on inside of me. Because I was thinking about me when I was doing that. I wasn't thinking about my client. And I said, oh shit, I got to the opening statement. And I now get to the cross-examination of the main witness, because that's all we want to do. We want to cross-examine somebody. This is all in the way. All right? So we miss a lot of opportunities by this crap. And let me explain something to you. The presumption of innocence and the burden of proof ain't defenses. They ain't ever been defenses. They ain't ever going to be defenses. Okay? It means, first of all, that the government story is absolutely right, but you got to look at it a different way. That's all you're saying. So you've given up the whole courtroom in reliance on a bunch of words on a piece of paper written by a judge that not even we can understand. You've given up the defense of the case. They're not defenses. The credibility of the witnesses is not a defense. It's not a defense. It doesn't defend anything. Nobody knows what the hell you're talking about. And I've seen lawyers read the instructions to the jury. As the jury, all right? Those things are not defenses. They may be part of a story. They may help you tell a story. But they don't defend shit. And the other problem with it is it's such a concession. is such a concession that you have given the field up to your opponent. Let me give you some ideas about storytelling for a second. I've been reading a great book. Any of you get a chance to read it? It's by a guy named George Lakoff. It talks about the 21st century mind and the 18th century mind and why, essentially, this book talks about why Republicans win and Democrats lose and what the appeal is. And he begins to speak about things called cultural narratives. And one of the illustrations that he uses in the book is how ambivalent everybody was about Anna Nicole Smith. And his theory was that she fit a myriad of cultural narratives. And that's why people had trouble making decisions about what to think about the whole thing. So let's go to the next one. For instance, she fit a rags to riches cultural narrative. These are all things that you can use in the development of a story. Give me another cultural narrative. Hero-heroine cultural narrative. Starts out poor and unknown, through the exercise of will and discipline, does something extraordinary. That's part of our cultural narratives. Those are favorable cultural narratives. Those are things that you should begin to think about. Giving you an example. Take, for instance, a woman who marries well and marries an abusive husband and ends up beaten up. Some of these cultural narratives will maybe fit that story. That as a story. Go ahead, sir. Next one. Reinvention of self. Through a new name, a new identity, Vicki Lynn Hogan became Anna Nicole Smith. So she reinvented herself. That's a cultural narrative. That can be part of a storytelling opportunity. You can begin to look at your clients in these ways. Give me another. Everyone first fails, looks like a loser, then successes redeem her. These are all positive cultural narratives, places where you might want to put a client in the course of this. But these are cultural narratives. There are others. I just chose Anna Nicole Smith because of the ambivalence, and it was chosen in the book. What's another one? Gold digger. Here's the other flip side. Heartless, ruthless, manipulative, sleazy gold digger marries a man 60 years her senior for his money. The prostitution narrative. This is how they would frame the issue. Yes, sir. How to marry a millionaire. This is a famous, what's the woman's name with yeah. No, more recent, Julia Roberts in Pretty Woman. This is a Pretty Woman there. But these are all parts of things that people in our culture are aware of, can seize upon in the course of a storytelling event to place your client in those frames. Go ahead, next one. A woman's lot. Has to navigate a world of bad men trying to find a better one, and to make use of her sexuality to succeed. It's another cultural narrative. Go ahead, the next one. I want you all to think about this chart. It's a very interesting chart because it teaches the notion that you have to be, in the course of creating your stories, careful with words. Black and white, dark, and what have you. And what the implications, the linguistic implications are. And how morality and this all plays into the mind of human beings, the people sitting in the jury room. Everybody get a chance to see that? Excuse me? Can't read it?
It's hard to read from that.
Oh, okay. I'll just give you a couple examples. You are better off if you can stand upright than if you cannot. Morality is uprightness, immorality is being low. Linguistic examples. An upstanding citizen, high moral standards, above reproach. A low thing to do, underhanded, stoop to that, a snake. You are better off if you are functioning in the light than in the dark. Morality is light. Immorality is darkness. Snow White, the Prince of Darkness, white hats, black hats, a white knight, black party. I don't know why that works. Don't work for me. Okay? That works backwards for me. But in any event, next one, just giving you some idea. You are better off if you eat pure food than if you eat eat rotten food. Morality is purity. Immorality is rottenness. Pure as the driven snow. Purification rituals, a rotten thing to do. That was disgusting, tainted by scandal. These linguistic examples show how people's minds function when they hear these words. What they begin to think about. They think in the term of metaphor. And you've got to think in the term of metaphor because what your job is to give them the metaphors that support your case, that they can rely on, that they've heard somewhere at some other time. And that's what this story allows you to do. You can go to the next one and go to the next one. 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 I want to talk about framing. And you're going to see a great example of framing this week. How many of you heard about the New Yorker Code? All right. For those of you who haven't heard about the New Yorker Code, New Yorker is a magazine in New York, probably read by most of part of the elite cafe society in New York. Authored for them. On the cover this month, this week, is a picture of Barack Obama in Arab garb in the White House with the flag of the United States burning in the fireplace, and a picture of Michelle Obama in an afro with an M60. That's the cover shot of the New Yorker this week. Now, what's happened, and when in talking about framing, I want you to understand what's happening. It's done as satire, supposedly. Okay? And the New Yorker is likely to feel that it did it as satire, because that's the New Yorker. However, it adopts a cultural frame, a frame of reference that conservatives would like to put Obama in. And now what happens here is once that frame becomes the cultural model, it is very difficult to overcome the nature of framing. Someone on television this morning said a survey had been done, and while most people now don't believe that Barack Obama is a Muslim, they believe he's educated in a madrasa, which is not true. But the frame has been set up, and people adopt frames according to their emotional state and where they see themselves in the world. And to give you an example of what we're talking about, framing. In my two major terrorism prosecutions, I represented Dr. Samuel Larian in Tampa, Florida, and I represented Dr. Adel Halim Ashkar in Chicago. And in both cases, there had been a lot of press and a lot of discussion about this was a terrorism case. The government had created a frame. When Ashkar spoke about Samuel Larian and spoke about Adel Halim Ashkar, they were framing the case. They were framing the case for the jurors. They were telling the jurors that we were going to have a case about terrorism. And what else were they telling? What were they telling? Once I use those terms, what am I telling? Nobody knows?
9/11.
9/11. What else?
Moms.
Bombs. What else?
Anti-American.
Excuse me?
Anti-American.
Anti-American. What else?
Bin Laden.
Bin Laden. What else?
Your kids aren't safe.
All right, your kids aren't safe. What was the emotion they were evoking? Fear. All right? So you got to understand, frames evoke emotion. So in the framing of that case, the government told the world that this was a terrorism case. Now, when we looked at the case, Sammy's case first and Alarian's case second, we understood, after looking a lot, after making a committed search through the facts, the case was about words. It was about speech. It was about people talking about political beliefs. And so we created an alternative frame. That this was not about terrorism, but it was about freedom of speech. And it was a frame understand. And in Alarian, what we did was we specifically looked for jurors who were immigrants. And the reason we were looking for immigrants is we decided that immigrants were closer to learning about the Constitution and having respect for the Constitution than the average American. Because the average American, the last time he's heard anything about the Constitution was when he was in some sort of a civics class, if at all, in high school. Immigrants came here because of the Constitution. We came here because of freedom of speech. So what we were trying to do was find a frame in telling our story that people could accept, an alternative frame to the notion of terrorism. And our theory and theme was, he had a right to say it. You, as a citizen of the United States, had a right to hear it. And the government had no right to repeat it. That was our alternative frame. That was our theory and theme of that case. That was it framed the issue in a different way than the government. I would lose those cases if I treated them as if they were terrorism cases. I would have lost. That's the fallacy of walking into a courtroom, and I live in the Eastern District of Virginia, so I saw a lot of terrorism cases tried. Heard about them, read about them. And in each one, the defense adopted the government's frame and said, but he's not a terrorist. Once you adopt that frame, you again give up room in the courtroom. Room that I want, room that I need. And so what we did, and Andrea knows about it because she was there. In each of those cases, we read the Declaration of Independence to the jury in closing argument. Probably the first time they heard the whole document. In each one of those cases, and in another one, a little side story, is we prepared a wanted poster in the Chicago case of George Washington. And we used it as a demonstrative evidence in the closing argument. When the case was over, my wife, who runs my office, who's sitting in the back, gets a call from an FBI agent who wants a copy of the poster. Okay, this is an FBI agent that we just beat. But we found an alternative frame. That's what storytelling allows you to do. It allows you to create an alternative frame of reference for your jury to begin to think about this crumpled set of facts that you got to deal with. Now, is that better than Dr. Alarian is presumed innocent and the government has the burden of proof? I had a story to tell. A story that every one of those jurors could understand. Now, how do we get there? What do we do? Next. Emotion. Your most important weapon in a courtroom that we need to understand and we need to utilize in the representation of people accused of crime is emotion. We cannot allow the government to wield all the emotion in the courtroom. Now, what emotions does that evoke?
Fear, anger.
Come on, guys, wait a minute. What emotions does that evoke?
Terror, disgust,
Right. What else?
outrage, heroism.
Sympathy. What else? Josh, you got shut up. Okay. What else? Come on, people. Shock. What else? Sadness. What else? Nothing else?
Guilty verdict.
That ain't an emotion. Go ahead. What else? Okay, what else?
Hate.
Anger. What else? Hate. What else?
Fury.
Okay. Grab the next slide. Your opponent gives you all of that. starts his case, telling a story, and he's got pictures, he's got fingerprints, he's got DNA evidence, he's got all of these things to tell his story that is designed not to get people to think rationally like the jury instructions suggest, but to piss them off. At who? At your client, right? From the moment they step to the podium, they are evoking emotion in the case. From the moment they walk in front of that jury, you know, we had a guy in the Eastern District of Virginia that had evidence on a gurney, Justin. And he would walk into the courtroom with his pushing his gurney, and he would be sure that that motherfucker's sweet. So everybody in the courtroom turned to the evidence, then he would walk over to it, pick up evidence from the moment he came into the courtroom, people were focused on his evidence. He was creating emotion, and he was using the squeaky gurney to help him persuade. Look at all of this stuff I got on this squeaky gurney. How are they going to stand up and deal with that? And lawyer after lawyer would get up and say, my client's presumed innocent, and the burden of proof is on the government. And the jury would look at the card and say, yeah, it sure is. Okay? Okay? How do we do it? What do we do to evoke emotion? How do we bring some of the things that are part of the human experience to bear to our benefit? That's like. First thing is, it's your problem. It's not the jury's problem. How many of us is that said? You know, I lost that case. That was the dumbest jury I've ever seen in my life. They didn't listen to a word I had to say. You know, we had one smart person on there, they would understand what I'm talking about. This is when you talk to your colleagues. I did a tremendous cross-examination. Everybody understood what I was doing, and they were so stupid they didn't follow what I was doing. Ladies and gentlemen, it ain't their job. It's your job. It's your job. If that's where you end up, you failed. You didn't teach. You didn't learn. Your students, for the several days before, your lesson plan failed. You didn't teach them. You didn't make them understand. That's why you're there. Your sole purpose for being there is to make them understand. You have no other purpose. You have no other purpose. It is your problem. You must wake up to the idea that it is your problem. If you don't reach them, it's not because of them. It's because of you. One of the ways to reach them, I'll come back to, is a story. The story has a beginning, something to capture people, a middle, and an end. And that's where you got to start learning to tell stories in the courtroom. You got to come out of what you've been comfortable with. And this is the place to do that. I don't want anybody comfortable here. I want you all uncomfortable. Trying new stuff, doing different stuff. Come on, let me go to the next one. Remember we started this by saying, develop a short phrase that conveys the essence of the case and can be repeated through the dramatic moments. That's all. You must find what the facts tell you are the emotional center of the case, how people are going to feel, and how you can exploit that emotional center, how you can grab it. But this requires an analysis of the facts that is very different from the ones that we have been taught to do. One of the great problems with law school is the following. We tend to think about things in terms of what we consider defenses. So when a client walks into our offices and is being interviewed by a lawyer, we take enough facts from the client to find out what we think the defense is. And we go, oh shit, the defense is self-defense. Oh, we're finished. No more analysis of the facts. No more analysis of the defense. No more anything else. Because we found that legal set of terms, that category that we've been trained to accept in law school, and we've accepted it, and that's the end of the inquiry for us. This kind of theory and theme requires a much more in-depth understanding of the client, the circumstances of the client's life, the circumstances of the event. Because in order to tell a story, you cannot tell a story by simply saying it was self-defense. It doesn't tell the story. That's it. Now, here's where the fun is. This lecture is a part of a lecture that Raymond Brown, who teaches here as well, and I gave many years ago. And we wanted to figure out how people thought about things and how emotion was evoked in everyday life. Okay. And what we, being the age that we are, and I will not say, all right, I will tell you that age is like kryptonite. You know, every day you wake up with a new pain. But being our age, I can sit down in a room and hear a Motown song and feel what I felt 40 years ago. I can feel those emotions again. I can think about that history again. So how does that happen? What are they doing to me? What to cause me to begin to feel those things? And the first thing the next level. The first thing we decided was what they were doing was telling stories. Stories that every human being could relate to. And they were not telling them with multi-syllable words, with words that people don't understand. So we took a Motown song and we deconstructed it just to see what the hell was happening. And this was the one we chose because at the time in my life, it was before I was married to my wonderful wife, and I was by myself, so that's how I felt. But this one was great for evoking emotion in me at that point. And we began to look at the words. Now, if you look at these words, these are words that every human being on the planet can understand. There's nothing difficult about this. The sun is shining. There's plenty of light. Does that evoke emotion? Can you see that? Is he painting a picture with words, telling a story? The new day is dawning, sunny and bright. You all get that? Hard to get? Has he used credibility or presumption of innocence? All right? Does anybody in this room have a difficulty understanding those words and what that story says? Then watch what they do. How they play with emotion here. He sets you up. He creates this beautiful day where light and the sun is coming out and what have you. And yet, the next line, he trips you up. But after I've been crying all night. Now you're going to remember that. There's no way you're not going to remember that. You're going to remember that this person was astute enough to observe the sun and a nice day and it was beautiful, but his emotion was such that he was crying all night. What does that evoke? What emotion does that evoke? Sadness. Sadness. What else?
Despair.
Sympathy. What else?
Despair.
Despair. What else? Empathy. Empathy. Nice word to have in the jury. The sun is cold and the new day seems cold. Now, they've played with your head with nothing more than a series of two-syllable words. They've played with your head. They've evoked all kinds of emotions in the people in this room, but they never went beyond two syllables. Now, not only can everybody in this room with their law degree understand this, everybody sitting on a jury can understand this. And this is just an illustration of how you can evoke emotion, because music always evokes emotion. It's designed to evoke emotion. But if you pay attention to the lyrics are equally designed to evoke emotion and feeling. And what we want you to do is we want you to become songwriters. We want you to begin to think about this process of how do I take this set of facts that I have and turn it into something where a jury is going to begin to emote in a favorable emotion to my client. And that's it. And this is a very simple method for doing this. Because we talked about a lot of things and you need a method to try to get there. Any analysis of the case ought to be, I don't care if it starts with this, or ends with this, an analysis of the facts, and a listing of the facts, and good facts. What facts do I want the jury to grasp? What facts in this factual pattern are important to me? What facts make my case? What facts tell my story? What facts illustrate that this was not a murder? What facts are there? What facts mitigate if we're talking about a battered woman's type situation? What are the good facts? And the good facts vary from case to case. The other thing you need to know is some things that are observable to you when you first look at a case, if you do the right analysis of the case, that you consider bad facts, ultimately can be turned into good facts with a different analysis, with a different perspective, with a different viewpoint. And what your goal is here is to run these facts through as many perspectives as you possibly can. I talk to everybody in my office about my theories and things. I want to know what my secretary thinks about what I'm saying. I'm not quite interested in what the other lawyers think, because most of the other lawyers at this point, because I'm old and what have you, been doing it for a while, they're going to tell me what I want to hear. But what I'm interested in is how lay people react to a set of facts. I talked to my mother, who is the biggest conservative in the world, about a theory of the theme in a murder case or a robbery case. Because I want to know what she feels. I want to understand how she perceives it. You have a rape case. I'm a man. I don't know what sex feels like from the perspective of a man. For me to get up and talk about it in front of the jury without some understanding of that conveys a sense of arrogance and probably turns off every woman in the room unless I can find a way in the course of explaining my defense to let them know that I know. And you have to think about that, because you, as men, you don't know. Much as you may read a set of facts and think you know, you don't know. And you can't just limit yourself to your own views of the world. Because first of all, your views are stilted. Have you been listening to this political campaign? Has that told you how stilted your views are? You are part of the elite. You view the world from a perspective that not everybody else does. And you need, in trying a case, you need as much information as you can get. So we begin to list the facts and we begin to become comfortable with them. Not afraid to stand in front of jurors and speak the facts. Because all of this other stuff that we've done, all of this other stuff that we've hidden behind, all of the jury instructions and the presumptions and the evidentiary bullshit is a way that bars us from actually communicating with people and understanding how people deal with this. So you must become comfortable with these facts. I want to be able to feel when I walk into that courtroom, I want to have spoken those facts and thought about them enough. I feel like I'm in my living room, talking to my best friend about the new case I got. Because if you do that, if you begin to feel that way, you lose that anxiety in that ass. only people, you're not the first set of people, you're not the only people, we all have it. Next, please. And as we put the facts together, we begin to understand that there are certain witnesses in the case that can convey those facts. And we begin to list those people. We begin to think about those people. We begin to put together what we think the case is going to look like. And finally, the next part of this analysis is the bad facts. You got to list those too. Because those are the ones you got to confront and overcome. And you got to decide in the course of your defense how you're going to confront them. For instance, in the terrorism cases, we conceded the speeches. He made them. He said those horrible things. Horrible things are part of an active country with a First Amendment. People speaking horror is difficult to accept, but it is part of a country that has a First Amendment. And we told people about the Ku Klux Klan and everybody who said horrible things. So we became comfortable with the bad facts. We knew all the bad facts. And as we looked at the bad facts, we found some interesting things in both terrorism cases. That some of the horrible things that were being said were being taken out of context because as we understood the facts, we found some of them to be scriptural quotes from the Quran. And they were allegories and allusions to other things. And when the translator got up on the witness stand, we could ask him the question because we had done the analysis. Well, didn't that come from the Quran? And he would say, I don't know. But once we had planted that into the jury's mind, then it didn't become the speaker of our client, it became textual. But that was only because we were familiar with the bad facts. We knew what the government was going to say. And we turned those bad facts around on them. So you must be comfortable with the bad facts. You need to take them and you need to confront them. Because what happens in a trial if you don't confront them? They're left. And no matter how weak you might think it is, you have got to find a way in your story to confront what the government suggests to you are the bad facts, which you know are coming. And I know there are some cases that have a lot of good facts, and then there are cases like mine and have a lot of bad facts. But if the bad facts are the good facts, that's more important for me to become familiar with them. So once you do that, you put them on a piece of paper, you look at them, and you begin to try to find that short phrase that you can use to create your own set of dramatic moments. It's not easy sometimes. It's hard. It requires a lot of time. And it requires an assessment with other people. And it requires as much information as you can gather. But that's your duty. That's your commitment. That's your commitment to the cause of this particular crime. Ladies and gentlemen, that's what a theory and a theme is about. That's what it will do for you. I didn't really learn how to try a case, frankly, until I learned how to do this. Before then, I was parroting words of lawyers who had appeared before me for hundreds of years. It was not Bill Moffitt. Once I got into this,